Hello friends, in the series on the income tax cases, today we will discuss a very important issue that if any assessment order is to be passed by income tax officer and the assessment order is passed by the Deputy Commissioner of Income Tax, which is a violation of Central Board of Direct Taxes Instruction number 1 of 2011 dated 31st January 2011. So whether the assessment proceedings are liable to be quashed only on this ground that the assessment order has not been passed by the income tax officer and it has been passed by Deputy Commissioner of Income Tax. This issue has been taken up by Honorable Delhi ITAT A bench in the case of Aashiyana Infrastructure Development Private Limited versus Deputy Commissioner of Income Tax. This case is reported in 126 ITR Tribunal, short notes 31, and the date of the judgment is 4th July 2025. The present case relates to the assessment year 2008-9, and in the present case there was a survey by the Income Tax Department on the Assessee and its various associated entities. Due to that survey, the notice under section 148 was issued to the Assessee for the assessment year 2008-9, and in the present case the notice has been issued under section 148 by the Additional Commissioner of Income Tax. When the assessment proceedings were going on, it was the allegation of the revenue that the Assessee has received some accommodation entries for which the Assessee has not able to prove the identity, creditworthiness and genuineness, and there are some undisclosed investments of the Assessee. The Assessee gave its submissions, but it was not accepted by the income tax officer, and hence accordingly the additions were made. When the matter was before the CIT appeal, the CIT appeal also upheld the order of the assessing officer, so the Assessee moved to the tribunal. In the tribunal, the Assessee raised the legal additional ground that in the present case, the notice under section 143 subsection 2 has not been issued. The second legal ground was that the Deputy Commissioner of Income Tax has passed the assessment order in spite of income tax officer, so there was no jurisdiction to pass the assessment order, and the Assessee was also raising the ground that in the present case, since the file has been transferred from the income tax officer to the Deputy Commissioner of Income Tax, there is no section 127 order, so the jurisdiction is not there for the Deputy Commissioner of Income Tax to pass the assessment order. The department was pleading that in the present case, the assessment order has been passed by an officer who is having the higher rank, so the assessment order should not be quashed on that ground. But when the tribunal heard the matter, the tribunal, by relying upon the two judgments, first Bombay High Court judgment in the case of Ashok Devichand Jain versus Union of India, which is a 2023 judgment and which is reported in 452 ITR at page number 53, and another judgment, that is Vipul Mittal versus Deputy Commissioner of Income Tax, which is a very latest judgment of 2025 and which is reported in 131 ITR Tribunal at page number 621. By relying on these two judgments, the tribunal said that in the present case, the assessment order has been passed on a defective notice which has been issued by the Additional Commissioner of Income Tax while he was having no power to issue the notice under section 148, and in the present case, since the revenue is not able to demonstrate that there is any 127 order to transfer the file from the income tax officer to Deputy Commissioner, so the assessment proceedings are not valid in law. The tribunal said that in the present case, according to Central Board of Direct Taxes Instruction dated 31st January 2011, the assessment order is to be passed by the income tax officer since the loss of the assessee was rupees 10 lakh, and hence this assessment is to be done by the income tax officer and not by the Deputy Commissioner of Income Tax, so the whole assessment proceedings are liable to be quashed. The tribunal said that since the proceedings have been quashed on the technical ground, so there is no need to adjudicate the other issues. Friends, this is very important judgment, because in a number of cases it happens that the assessment or the notice is to be issued by the income tax officer, but it has been issued by an officer which is of higher rank, or vice versa. So in all those cases, these type of judgments are very helpful for the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Aashiyana Infrastructure Development Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 126 ITR Tribunal Short Notes 31, and the date of the judgment is 4th July 2025. Thank you, friends.